Hey there, I'm the MadCatster. I'm glad to see you here. Well, you may recall the story of the TikTok psychic and the way she inserted herself into the investigation into the deaths of some University of Idaho students, how she claimed she had visions of who the real killer was, and she accused a professor at the university. Well, that professor ended up suing her, and that lawsuit is still going on, but there's been some developments because the TikTok psychic still isn't doing what the court had ordered her to do. And now the plaintiff, the professor, has filed a renewed motion for summary judgment to try to resolve this case and get judgment completely in favor of the professor. We're going to take a look at the new motion, what has happened, what the TikTok psychic has failed to do. You know me, I've got the deets and all the receipts. So buckle up and let's go. So I'm here with Cedric. Sybil's upstairs. I called her. She's fine, actually. I called her. Cedric is here with me to do Sybil's job. Cedric says, please like and subscribe. We're headed toward 45,000 subscribers and then hopefully on to 50,000. With your help, we can get there. I know more than half of you aren't subscribed, so please like and subscribe. We would really appreciate it. Sybil, by the way, the good news is her mouth appears to be in remission. She seems to be fine. Now, some of you may know my deaf cat, Stefan, my white cat. He is terribly ill. A lot of you, I want to thank so much for your generous donations to the fundraiser, and the donations you guys made are going to help pay for those visits because he's going to have fluid drained regularly from his abdomen and other tests and medication. Some of you have asked me if you could still donate. Yes, you can. Please do not feel obligated, but if you want to, the link is down below to the fundraiser. All the money is going towards his visits that he'll have probably each week to offset the cost. Is very expensive. I've already spent like over $1,200 on just on 2 visits. I've got some people to thank. The Amazon wishlist, which is the link is in the description below. I'll do that at the end of the video. Also, if you stay tuned to the end of the video, I'm going to give you more complete explanation of what's going on with Stefan and what his history is, etc. Some of you may not know his story. Anyways, let's talk about the TikTok psychic. Okay, she is a character. A lot of you who have been following this story, and I've done several videos on this now as the lawsuit has progressed, will know that not only did she falsely accuse this professor of directly being involved in the deaths of the students at the University of Idaho, but once she was threatened with legal action, instead of backing down, she doubled down and she continued to insist, and she still continues to insist to this day, that she is right and this innocent professor is somehow involved, even though the alleged perpetrator has been arrested by the police and they believe they have the right person. They have the evidence to back that up. The professor's not involved at all. So this defamation lawsuit has gone on. And at first, the TikTok psychic defaulted. Then the court gave her another opportunity, which I've told you guys in the past. The court is generally very lenient, especially with pro se defendants. They gave her another chance. They let her remove the default. She, I believe, filed her answer late, even though she got the second chance, and she hasn't cooperated with the discovery. She failed to give answers to the requests for admissions, which are basically statements. And we've talked about this. If you want to see my other videos, go take a look at those and you'll get the whole story. The professor had filed a motion for summary judgment back, I believe it was in December. The judge didn't grant it. Instead, she ordered the TikTok psychic, Ashley Gillard, to answer the discovery and gave her the opportunity to do that. But she said that the plaintiff could file a renewed motion for summary judgment if the TikTok psychic didn't resolve the outstanding issues, and also if it's clear judgment should be in favor of the plaintiff, the professor. Well, that's what's apparent from everything that's happened, because there's been no evidence put forward that in any way shows that the TikTok psychic, Ashley Gillard, is not liable for the defamation. So now they filed this renewed motion for summary judgment. And we're going to go through just like the fact portions. I'm not going to go through all the legal analysis, but I'll give you an explanation as we go along. I'm just going to go through like what the facts are and like what's happened that's brought us now back to this motion for summary judgment. So let's take a look. So you see here Rebecca Schofield versus Ashley Gillard in the U.S. District Court, which is a federal court for Idaho. And this is the memorandum in support of the plaintiff's amended motion for partial summary judgment. So you see here it says, Plaintiff Rebecca Schofield, also known as Professor Schofield, respectfully requests that the court enter summary judgment on both her claims against defendant Ashley Gillard. As a matter of law, Miss Gillard has admitted to defaming Professor Schofield, which in fact she absolutely has. And like I said, she continues to double down to defaming Professor Schofield. Miss Gillard's admissions, the TikTok video she posted online, and Professor Schofield's declaration established beyond dispute that Miss Gillard is liable for her defamation of Professor Schofield. Accordingly, all that remains is for a jury to determine the extent of Professor Schofield's damages. So in other words, if the court grants this motion for summary judgment, then the only thing that's going to be for trial, it's still technically called a trial, even though it's not like the trial, to determine how much money should be awarded to the professor based on the damage that's been done, which I think is pretty extensive. And then the background. So it says, in November 2022, 4 students at the University of Idaho were unalived at a home near campus. Ms. Gillard, a resident of Texas, took this tragedy as an opportunity to post sensationalist content online to attract clicks and make money. According to Ms. Gillard, she used her spiritual practice, psychic abilities, and metaphysical tools, including tarot cards, which we all know tarot cards are a very important part of every police investigation, to post over 100 TikTok videos of her supposed findings concerning the deaths near the university. Ms. Gillard's purported findings, which she posted on the social media website TikTok, went like this. Professor Schofield had an affair with one of the victims and then planned, initiated, ordered, and executed the deaths of the students. Ms. Gillard has admitted that she made these sensational statements, although now she claims she was just relaying the results of a tarot card reading. Again, very scientific. And she has admitted that these statements were not based on any facts. So, in other words, she's admitted that she didn't have any other facts to base all of these false statements on, except the tarot card reading and her psychic abilities. And that's how she knows that the police are wrong and she is right. Ms. Gillard has also admitted that her false statements are based on her spiritual research, intuition, and instincts, and that she currently has no written information or oral information from another human being that support her false statements. She states that she hopes to find facts to support her position through discovery in this case, but so far she has none, even though discovery is closed. Now, Ashley Gillard, the defendant, tried to go on what we call a fishing expedition. She basically wanted all kinds of irrelevant information. She wanted extensive personal stuff from the professor. Basically, she was going to comb through stuff to try to find something to support her claims. Well, you can't do that. Discovery has to be narrowly focused, and you have to ask specifically for certain things, and they have to be relevant. Hers wasn't relevant. The court said, no way, you can't go on a fishing expedition. So now she's basically got nothing to show for her allegations. And the professor rightly is saying, okay, it's clear that she's got nothing. Therefore, there is no case to try. And I agree. In a good faith attempt to resolve this matter without litigation and to avoid drawing further attention to Ms. Gillard's utterly baseless statements, Professor Schofield sent cease and desist letters to Ms. Gillard on November 28, 2022 and December 8, 2022. Ms. Gillard received these letters and promptly disregarded them, instead choosing to continue spreading false information for her own pecuniary gain, meaning like for money, because they assumed that she got compensated on TikTok. Given Ms. Gillard's willful disregard of the cease and desist letters, Professor Schofield filed her complaint, asserting 2 defamation claims, one relating to Ms. Gillard's false statements that Professor Schofield was involved in the murders, and another relating to Ms. Gillard's false statements that Professor Schofield was romantically involved with one of the victims. Professor Schofield filed her 2-count complaint on December 21, 2022. Ms. Gillard failed to answer or otherwise respond to the complaint within the time called for under the federal rules. Professor Schofield filed a motion for clerk's entry of default on January 19, 2023. The entry of default was filed on January 27, 2023. After failing to respond to the complaint and being found in default, Ms. Gillard filed a motion for relief from judgment and an answer, affirmative defenses, and counterclaims. Professor Schofield responded by filing a motion for default judgment on February 17th and filed a motion to strike Ms. Gillard's answer affirmative defenses and counterclaims on February 27, 2023. Clarice has now joined me. On April 26, 2023, the court issued an order granting Ms. Gillard's motion to set aside entry of default. They granted Professor Schofield's motion to strike and denied as moot Professor Schofield's motion for default judgment. So in other words, the default, obviously, that motion was moot because the court said, okay, you can have a second chance to answer. But they did strike her counterclaims, which was basically Ashley Gillard making claims, and we've talked about this before, it's like a lawsuit in a lawsuit where she was trying to make claims against the professor, which were absolutely bogus. The court, in a very good decision, decided to strike those, so that put an end to Ashley Gillard's claims against the professor. In granting Ms. Gillard's motion, the court reasoned that her failure to timely respond was most likely an unintentional oversight caused by self-serving carelessness, and that it did not amount to bad faith with an intention to take advantage of the opposing party, interfere with the judicial decision-making, or otherwise manipulate the legal process. I don't know. I kind of disagree, but like I said, the court is very liberal when it comes to giving leeway to defendants to cure a default. Ms. Gillard refiled her answer affirmative defenses and counterclaims on May 16, 2023, and on June 6, Professor Schofield filed a motion to dismiss Ms. Gillard's counterclaims. The court heard argument on Professor Schofield's motion to dismiss, and it issued an order dismissing Ms. Gillard's counterclaims on August 8, 2023. So, even though the court had struck her counterclaims, Ashley Gillard then tried to refile her counterclaims, and the court said no, and they dismissed them when the professor asked, which I totally agree with. As this court noted in its order dismissing Ms. Gillard's counterclaims, the defendant merely responded that she believed her allegations about plaintiff were true, and that with discovery can find evidence that bears this out. To begin, defendant cannot use discovery as a fishing expedition, as we discussed, to find facts that might validate her counterclaims. This ready, fire, aim approach is not permitted under the federal rules. On August 22, 2023, Ms. Gillard filed a motion to set aside the court's order concerning the dismissal of her counterclaims, which the court also denied. Professor Schofield served Ms. Gillard with discovery requests, including requests for admissions, interrogatories, which are questions basically, and requests for production of documents pursuant to Federal Rule 36 on June 20, 2023. Ms. Gillard's responses to those requests for admission were due no later than July 20, 2023. Ms. Gillard did not respond to those discovery requests, including the requests for admission, by July 20th, which is when they were due. On October 6, 2023, based on Ms. Gillard having, as a matter of law, admitted to all required elements of a defamation per se claim through her failure to respond to any requests for admission. Because what happens is if you don't answer the requests for admissions, the court will then deem them as admitted. Even if you would have denied a statement, it will be considered admitted. Then the professor basically has made her case for why she should win. Ms. Gillard did not respond to any of those discovery requests until December 15, 2023. That's like 5 months late. After the court, sua sponte, means the court took action without a hearing or without a party requesting, sua sponte allowed her to do so during December 7th status conference. So the court, on its own, decided, well, you're 5 months late with discovery, but we're going to let you produce it now anyway, which I think is ridiculous. But again, like I said, courts give a lot of leeway to pro se defendants, although I think that's a little extreme in this instance because 5 months is a very long time. I think if she maybe had been 30 days late or, even maybe, 2 months late, but 5 months, I don't know. But that's the court's decision. The court also allowed Professor Schofield to file an amended motion for summary judgment. Hi, Antoinette. After Ms. Gillard served any late answers to Professor Schofield's request for admission. So, as I said, once Ashley Gillard responded to what the court gave her extra time to respond to, they said, even though we didn't act on your motion for summary judgment, you can file a renewed motion once we see what Ashley Gillard is going to produce. Professor Schofield sent a deficiency letter, which is something you do like before you ask the court to take action. You'll notify the other party that they have failed to respond, and you're giving them notice that if they don't respond within a certain amount of time, you're going to file with the court, either for summary judgment or some kind of default. So Professor Schofield sent the deficiency letter on December 20th, 2023, requesting responses by December 29th, 2023. Ms. Gillard sent an email on January 1. So again, several days past the deadline. Ms. Gillard sent an email stating that she was on vacation when the deficiency letter was sent and that she would get back to Professor Schofield by the end of the week. Ms. Gillard has still not responded. So Ashley Gillard, well, she knew what the deadline was. It doesn't matter that she was on vacation when the deficiency letter was sent. She already knew what the deadline was. So she's saying, oops, I was away, but I'll get back to you basically on my own time. And then she failed to respond. Now she's had more than enough chances. So now here's the argument of why they believe the court should give them summary judgment. Ms. Gillard's untimely responses to Professor Schofield's request for admission further established that Ms. Gillard published defamatory statements about Professor Schofield and that Ms. Gillard has no facts or admissible evidence showing that Professor Schofield was involved in the murders or that Professor Schofield had an affair with one of the students. Through her request for admissions, Professor Schofield sought admissions regarding Ms. Gillard making public statements that Professor Schofield was involved with the deaths of the students and that Professor Schofield had an affair with one of the students. And 2, the falsity of those statements. 3, that the bases for Ms. Gillard's statements was her spiritual research, intuition, and instincts, that she was not aware of any physical evidence or written information linking Professor Schofield to the deaths or to having an affair with one of the students. So that's what they were asking her to admit or deny. Through her response to Professor Schofield's request for admissions, Ms. Gillard now claims that she was just announcing the results of a tarot card reading when she made her TikToks and posted them on the internet, stating that Professor Schofield was involved with the deaths and that Professor Schofield had an affair with one of the students. But she admits posting them. So she admits to putting them out there to third parties to read. So that's basically why they're saying it's per se defamation. I mean, she doesn't have any defense, and she admits to doing it. And she admits she has no defense. So there's nothing to try. There's no question of fact here. She also admitted that she continued to state publicly that Professor Schofield was involved with the deaths and had an affair with one of the students, even after she received a cease and desist letter from Professor Schofield's counsel, and after she knew the Moscow, Idaho Police Department had issued a press release saying that Professor Schofield was not involved in the deaths. Ashley Gillard also admits she's never received any information communicated to her orally that Professor Schofield ever met the victims. So Ashley Gillard doesn't have any written or other evidence. She also doesn't have any statements or any information that she heard that would lead her to believe that she was correct in this fantasy that she was spinning. In response to a request for admission asking her to admit she had no written information or physical evidence showing that Professor Schofield ever met the students, Ms. Gillard stated she could not admit or deny because discovery is still pending. Public information from the victim's social media may show that the plaintiff met the students. Ms. Gillard responded similarly when asked to admit she knew of no physical evidence linking Professor Schofield to the deaths, or that she was not aware of any physical evidence showing Professor Schofield had an affair with the student. She stated, "I deny this matter. There's plenty of evidence to be discovered during the civil discovery process or criminal trial." So in other words, she has nothing to back her claims up, but she's hoping that if she had been allowed to go on that fishing expedition, she might stumble across something that would give some credibility to the nonsense she was spouting. Well, that's not how it works. In response to requests for admission asking Ms. Gillard to admit she had never communicated the actual suspect that was arrested, she responded, "I cannot admit or deny this matter. Many people have anonymously contacted me by way of electronic communication." So they've anonymously contacted her with what? Fictional information. If she claims she has no physical evidence or she's not heard anything, then these emails can't possibly contain evidence to prove what she's saying. She's already said she has nothing and she needs discovery to try to help her find something. So I don't know. And anonymously, I mean, would never be admitted. In response to a request for admission asking Ms. Gillard to admit her statements were false, Ms. Gillard denied the request for admission and stated that Professor Schofield has not proven that she didn't have an affair with the student or that she was not involved with the deaths. Okay, well, that's not how it works. You don't have to prove you're innocent. They have to prove you're guilty. So Sorry, that's not how that works either. Finally, Ms. Gillard admitted she did not have any written information showing that Professor Schofield ever met the University of Idaho student that Ms. Gillard publicly stated Professor Schofield hired to unalive the students. She stated, as of today, December 15, 2023, this matter is admitted. However, discovery is still pending. So she admitted that she didn't have any information to back up those claims. In short, Ms. Gillard has admitted she had no affirmative facts that indicate in any way that Professor Schofield had an affair with the student or was involved in the deaths, nor will she develop any. The discovery deadline was December 15, 2023, the same date that Ms. Gillard served her responses to Professor Schofield's request for admission. Thus, fact discovery is closed, and that's correct. So there's no more opportunity for her to produce evidence to back up her claims. And she can't just wait till trial to suddenly produce evidence. They've asked her for the evidence. She said basically she doesn't have it. That's it. She's got nothing to produce at trial as evidence. And so she loses. And so that's why they're doing a motion for summary judgment. They're asking the court, we don't need a trial. We just want the court to rule on the facts and the evidence that there is absolutely no way that Ashley Gillard is going to defeat this lawsuit, and therefore judgment should enter for the professor. And then it just goes on to talk about how, she stated publicly that the professor was involved in the deaths, that she publicly stated Professor Schofield had an affair with one of the students, that she continued to make public statements after receiving cease and desist letters, and after becoming aware that the police had issued a press release saying they didn't believe the professor was involved. Ms. Gillard has no evidence or facts showing that Professor Schofield was involved in the murders. Ms. Gillard has no evidence or facts showing that Professor Schofield had an affair with one of the students. And I'm going to skip the rest of this and we're going to go to here. So it says, Professor Schofield is entitled to judgment as a matter of law in count 1. And this concerns the false and defamatory statements that Professor Schofield was involved in the deaths. And it talks about how she posted the videos where she made the false claims that the professor was responsible for, ordered, or was otherwise involved in the deaths of the students. Ms. Gillard publishing of these videos on TikTok constitutes a communication as a matter of law. And because Ms. Gillard's statements impute criminal conduct for which the punishment is greater than a year in prison, the statements are defamatory per se. Accordingly, Professor Schofield is entitled to summary judgment on count 1. So they're basically saying she's admitted to doing this stuff. She's got no evidence to show that there's any truth to what she said. She's accused her of serious criminal conduct, which would subject the professor to a jail sentence of more than a year. And therefore, under the law, this is defamation per se. And then it says, Ms. Gillard admitted she publicly stated that Professor Schofield was involved with the deaths. And this admission conclusively establishes that Ms. Gillard communicated information concerning the plaintiff to others. And then I'm going to skip through some of this legal argument. And then Ms. Gillard's communications were defamatory per se. Ms. Gillard's statements unambiguously impute to Professor Schofield conduct constituting a criminal offense that would be punishable by imprisonment in a state or federal institution. Ms. Gillard variously asserted, falsely, that Professor Schofield unalived the students, was the one to initiate, plan, and hire the supposed hitman, ordered the deaths of the students, and broadly claimed that Professor Schofield was involved in the deaths. Indeed, Ms. Gillard has admitted she stated publicly that Professor Schofield was involved with the deaths. Ms. Gillard's admissions and the uncontroverted evidence in this case conclusively establish that Ms. Gillard's statements impute to Professor Schofield conduct constituting criminal offense that would be punishable by imprisonment in a state or federal institution. Accordingly, Ms. Gillard's false statements concerning Professor Schofield's purported involvement are defamatory per se as a matter of law, and this court should determine as a matter of law that Ms. Gillard is liable to Professor Schofield. Hello, Antoinette. I don't know if you can hear Antoinette purring away. Professor Schofield is entitled to a judgment as a matter of law on count 2. As with count 1, Ms. Gillard's admissions established as a matter of fact that Professor Schofield is entitled to judgment on count 2. Ms. Gillard admitted to posting TikToks containing assertions that Professor Schofield was in a romantic relationship with one of the students. Although she now states she was just announcing the results of a tarot card reading, she's also now admitted she currently has no evidence to support her false assertions. In her December 15, 2023 responses to Professor Schofield's request for admission, she acknowledged that she does not currently have any facts showing that Professor Schofield even knew the student she was alleged to having an affair with. The subpoena responses from the University of Idaho confirmed the absence of any communication or interaction between Professor Schofield and the student. Ms. Gillard communicated information concerning Professor Schofield to others for the same reasons as discussed above in reference to count 1. Ms. Gillard's TikToks that contain false assertions that Professor Schofield had a romantic relationship with the student constitute communications concerning Professor Schofield. As a matter of law, therefore, Ms. Gillard has admitted to the first element of the defamation claim asserted in count 2. And I'm not going to continue on with all of this, but because a lot of this stuff gets repeated, but they're talking about how the false statements about the romantic relationship were defamatory as a matter of law, that the fact that the professor could get into serious trouble with her university, could even lose her job if it were shown that she had improper relationship with a student. And this basically put the professor at risk of having her reputation tarnished, losing her job, and basically being publicly ridiculed and suffering damage. The statements ascribe conduct to Professor Schofield that's incompatible with the proper conduct of a professor. It goes on to talk about why any kind of relationship between the professor and the student would be incompatible with the university's own written policies, how it's just morally not the right thing to do, especially given the position of the two parties. And it goes on to talk about how the statements impute serious S-word misconduct to Professor Schofield, and again, how, her job could be in jeopardy, etc. And then it says that, the statements are defamatory per se as a matter of law, and the court should basically give judgment to the professor, and that no facts support any defense that Ms. Gillard's statements were true. No facts support Ms. Gillard's statements that Professor Schofield had any role in the deaths of the 4 students, or that Professor Schofield was involved in any personal relationship with one of the students. In her responses to Professor Schofield's request for admission, Ms. Gillard purported to deny the request, asking her to admit she had no factual support for her statements about Professor Schofield. However, the detail of her responses demonstrate that she has no such facts. She repeatedly stated discovery is still pending. Public information from the victim's social media may show that the plaintiff met with the students. Ms. Gillard responded similarly when asked to admit she knew of no physical evidence linking Professor Schofield to the deaths, or that she was not aware of any physical evidence showing Professor Schofield had an affair with one of the students. She stated, "I deny," in capital letters, "this matter. There's plenty of evidence to be discovered during the civil discovery process or criminal trial." Well, again, we know the court quashed that attempt at a fishing expedition, so basically she has nothing. Discovery is now closed. Ms. Gillard has no evidence that proves any aspect of her statements about Professor Schofield. They are false. Even Ms. Gillard's subpoena ducis tecum to the University of Idaho uncovered no evidence supporting her statement. So that subpoenas we were talking about to ask about evidence of some kind of communication between Professor Schofield and the students, nothing was produced because there was nothing. And that the University of Idaho responded it had no communications between Professor Schofield and any of the students. The University of Idaho also has no record of the students ever being enrolled in a class taught by Professor Schofield. Professor Schofield's statements in her declaration are undisputed. Professor Schofield did not know any of the students, did not have an affair with the student, was not even in Moscow, the town where the deaths occurred, when the deaths occurred, and was not involved in the deaths. Professor Schofield's undisputed declaration proves that Ms. Gillard's defamatory statements that Professor Schofield was involved in or orchestrated the students' deaths or had an affair with one of the victims were false. Ms. Gillard's responses to Professor Schofield's request for admission that her statements were based on a tarot card reading, which she believes, also do not give rise to a genuine dispute of material fact. At best, the tarot card readings are inadmissible hearsay, which is true. They're an out-of-court statement offered for the truth of the matter asserted. So in other words, well, they're calling it a statement. But the tarot card reading is basically being presented to prove the allegation she's making. And they're saying it's hearsay. You can't offer that as evidence because it's hearsay. Moreover, Ms. Gillard has no personal knowledge of the facts she divined from the tarot card reading. She states only that she believes the reading. This is not sufficient evidence to create a genuine dispute of material fact on the affirmative defense of truth for which she carries the burden of proof. So her defense was, well, they're true. What I said was true. She's got no evidence. And it's her, like they say, it's her burden of proof to produce the evidence to support what she said. And she's got nothing. As this court has stated when it dismissed Ms. Gillard's counterclaims on August 8, 2023, based solely on her claimed ability to psychically divine the truth, defendant makes extraordinary allegations about how plaintiff orchestrated the deaths of 4 people to cover up a secret romantic relationship with one of the victims. These claims are not only conclusory and unverifiable, but arguably so outrageous as to be clearly baseless and thus implausible. Ms. Gillard still has no verifiable or admissible facts to support her extraordinary and false allegations that Professor Schofield orchestrated the death of 4 people to cover up an affair, and there's no genuine dispute of material facts, and summary judgment as to liability is proper. In conclusion, for the reasons stated herein, Professor Schofield respectfully requests that the court grant plaintiff's motion for partial summary judgment and hold Ms. Gillard liable for her defamatory statements as a matter of law. The evidence conclusively establishes that Ms. Gillard's statements defamed Professor Schofield. All that remains is for a jury to determine the amount of Professor Schofield's damages. And so there you have it. There's the renewed motion for summary judgment. What do you think about it? Do you think that it's got a good chance of winning? Do you think that the TikTok psychic has made a serious error of judgment in continuing to push this? And she had an out a long time ago before this lawsuit was filed, and she didn't take it. Now she's going to pay the price. We've talked about this before. The professor will probably never see a dime from her, but the whole point of this is to exonerate, which she shouldn't even need to do herself, of all of this nonsense, and basically to have it on the record that Ashley Gillard defamed her and made false statements. So now my best guess is the court's going to grant this. I don't see any reason for the court not to grant this. There's absolutely no evidence to support Ashley Gillard's position. So there's nothing to try. The court is probably going to grant this. Then we'll move on to the damages phase. The court will schedule a trial for the sole purpose of determining damages, because the issue of the defamation will have been settled and judgment will have entered for the professor. The jury will be impaneled to decide how much money the professor should be awarded for this nonsense that Ashley Gillard put out there. And it's conducted like a trial, even though it's not to determine the liability anymore. And evidence will be presented and arguments will be made, and then the jury will deliberate like they would in a trial. They'll decide what the damages are based on guidelines from the court, and then we will find out what they're going to award the professor. That is, if this motion gets granted, which I think it will. Let me know your thoughts down below. I also want to thank a few people who generously bought me some cups of coffee. Adriana bought me 5 cups of coffee. Jenny Rabbit bought me 5 cups of coffee. Trash Queen Royale, I love that name, bought me a coffee. Olivia bought me a coffee. Thank you so much, you guys. I really appreciate that. All of that money, usually it's for me, but that's also going for Stefan's care. I would like to thank Jordan P., who sent us some Temptations Crunchy Treats, the 16-ounce tub, which we really appreciate. And also a big box of the Tidy Cat lightweight low dust litter. We appreciate both of those things. Both of those things, and the canned cat food especially, are the things we go through. If you want to send something, the wish list is down below. It's all stuff for the cats, nothing for me. And we would welcome anything you might want to send, and I will thank you on here. But now let's talk about Stefan and Antoinette. If you can probably hear her. She's purring like crazy. She's so loud. She's the sweetest cat too. Antoinette is such a good cat. But anyway, so okay. First, I'll just give you a brief history. Stefan, and you'll see here a picture of him snuggling with Sybil. He's a very sweet cat. I got him when he was 6 months old. He is deaf. He's always been deaf from birth. He was being fostered by somebody that's like 2.5 hours away from where I live. I had seen a notice because I was looking to see, I was back then anyways, I was looking because I didn't have nearly as many cats, for cats that really needed special needs or were in a difficult situation. Because he's deaf, they consider him to be special needs. They didn't want to just adopt him to anybody because obviously being deaf He can't go outside ever, and it requires a little extra effort. You can't talk to him. I talk to him anyways, even though he can't hear me. I talk to him just like any of the other cats. But you have to use, like I use, very visual. Like I'll look him in the eye, and we have certain hand signals. He knows, like, this is like 1 minute, or wait, or I'll be right back. Eat, sleep, get down, come here. I mean, we have our little language, and he's very cute. I call him Squeaky because he doesn't really meow. He goes, mm-hmm. So I've always just called him Squeaky because that's kind of what it sounds like. He doesn't really have a meow. So I went to see this cat. So I filled out an application. The foster asked me to come and meet him to see what I thought, and to, so they could basically size me up. I went, and she said to me, I'm going to go get him. And she did. And she said, now, don't be offended. He's probably not going to let you hold him. He doesn't like to be held. He doesn't let anybody hold him. It's just the way he is. I'm sure in time he'll warm up to you. Being very experienced with cats, I said, I'm going to pick him up anyways and see, how he reacts. So, Sybil's here. Come here, Sybil. Come on. Here's Sybil. Sybil, who's feeling much better, thank God. So I picked him up, and he promptly rested his head on my shoulder and fell asleep. And she said, it's meant to be. So I took him home. And I've had him for almost 12 years now. And he's been the best cat. He's never any trouble. He's very quiet. He's very sweet. At night, he comes every night and sleeps at my feet or next to me. And we have a very good, close relationship. And I consider him one of my special cats. I've, certain cats that have different needs or different requirements. Sometimes I call them my special cats because they require a little extra attention. And so he's been wonderful. So some of you already know that recently, very recently, he started accumulating fluid in his abdomen. I was very alarmed because it looked like he was carrying saddlebags. I was absolutely panic stricken. So I called the vet and they said, bring him right in. I brought him in. They did all kinds of tests. They did, like an x-ray to see what they could see. They really couldn't see anything because of so much fluid in his abdomen. They drained some fluid, like half a liter of fluid from him. Then the doctor got the results from the blood work and stuff, $800 worth of testing. And the next day he called me and said, well, there's an abnormal reading on one of the tests, like for his heart. He said that could be it. That's sometimes can cause the fluid in the abdomen. I'm not able to feel or see anything else. Most of his blood work is pretty normal. He said, so really what needs to happen is he needs an EKG to determine exactly what the issue is so they can hopefully... Oh, I don't know if you could hear that, the wind. The house just creaked. I have an old Victorian house, so it makes noise sometimes. The wind is very strong. I mean, strong. Anyways, so... Of course I was upset, but at least he gave me some hope. He said, they can prescribe, when they figure out exactly what's wrong, they can prescribe beta blockers or other medication that can keep it under control so that he'll, have a good quality of life and can live, for a while longer. So I felt a little encouraged. Of course I was sad. And I knew that, obviously, even if they gave him medication, this was probably going to start to be the beginning of the end. So I took him home, and a lot of you generously donated money to the fundraiser, and I was trying to get him an appointment. The doctor was trying to make a referral. It was like they were giving me like 2-month wait, and I'm like, well, I can't wait. He's like basically an emergency. So we had started talking about, well, I may have to bring him as an emergency and actually bring him there and sit there and try to get them to take him to do an EKG. And I was prepared to do that. That was fine with me, whatever it took. So he started to, get more fluid built up in his stomach over several days. And yesterday I brought him again. The doctor, I'm sorry. I waited to today to make the video because I thought I was be a little stronger. The doctor drained a full liter of fluid, which was basically all of the fluid that was in his abdomen, which I was glad because I'm sure it was terribly uncomfortable. And then the doctor could do another radiograph, and then he was able to feel, they call it palpate. And he found a golf ball sized mass and some enlarged lymph nodes. So he said, the heart isn't now my number one concern. He said, I think the main problem is he has cancer. And he thinks it's lymphoma, which, I said, well, can you remove the tumor? Well, what can we do? And he said, I could go in and operate. It probably would seriously endanger his life, so he might not even survive the surgery. And that if he did, it still wouldn't have cured it, that it can come back or, continue to develop in his body. And basically, he said, we can start him on medication, some steroids to try to shrink the tumor and hopefully at least get it under control enough that he has a good quality of life for however long he will be with me. So that's what we're doing. Now, what's going to end up happening, unfortunately, is probably like I did with my cat Louie, who had fluid in his chest. Is like every week I'm going to have to bring him in to get fluid drained from his abdomen. Of course, that's going to cost a lot. But what am I going to do? I'm not going to just throw in the towel. I don't want him to die. I love that cat so much. My oldest cat just died last month, and he was certainly not one of the ones I thought would be next on the list because he's only 12, and in cat years that's not that old. Sybil's gonna be 17, I think. I believe she's 16 now, so she's up there. Amelie was almost 18, so I wasn't surprised when she started to crash. And I've never had a cat that was younger than like 15 or 16 die. So it's really hard. And, the fact that he doesn't hear, I know cats don't understand English, but, there's studies have shown that they do understand some words. And, there's tone, there's a lot that you can convey to a cat through your voice and sounds that I can't do for him. So, of course, anytime I have to give him a pill, he struggles with me because he's afraid. He doesn't know what's going on. I can't verbally reassure him. I have to do it by looking at him and petting him. So he's scared, and when I take him to the vet, he's terrified because he has no idea what's going on. So, that's what our journey is going to be. We're going to have to take it one day at a time. I'm very, very upset today. He hasn't eaten anything all day. I gave him an appetite stimulant that the vet gave me, and I gave him his first steroid pill. So I'm hoping by the morning he's going to be hungry. He has been up and walking around. He keeps going over and laying. I put a bed next to one of the vents for the heat. He likes to go over there and lay while the heat blows up. So I gave him another spot that he goes is under a chair, so I made that nice and warm for him. I keep periodically, thank God I've been working from home the last couple of days. Periodically I go over and I sit and I pet him and, try to soothe him and let him know that I'm here and that, that I'm caring for him. And I keep trying to get him to eat stuff. I'm going to try again before I go to bed. I have some stuff in a pouch that's mostly liquid, that's like tuna fish, and I'm hoping that the smell of that is going to help encourage him maybe to eat a little bit. Also, he's been battling like an upper respiratory infection at the same time. He's been sneezing and sniffling and goop in his eye. And I said to the vet the other day, I said, will you please give him an antibiotic shot? He said, I don't think he needs it. Well, he hasn't stopped sneezing, and I think that's affecting also his appetite. So yesterday when I was there, I insisted. I said, if that cat dies and you refuse to give him that antibiotic that I'm requesting, I'm going to be extremely upset. And he hasn't had antibiotics in years because the only time he had an infection was in one of his eyes when he was little. So what harm is it going to do? Just give him the damn injection. So he finally did. So he does seem a little better today. I noticed that his eyes aren't as runny, so hopefully that too is kicking in. And I'm hoping by the morning he's going to be a little more energetic. We'll try to get him to eat. That's where we stand. As I said, some of you have asked if you could still donate, and you're welcome to. Again, please don't feel obligated. Please don't donate money if you can't afford it. I love all of you. I appreciate your support and your love. And I'm not even asking anyone to give. I'm just saying some people did ask. The fundraiser is still up. It will go towards his weekly care. That's great if you want to. If not, don't worry about it. But anyways, that's the story. Thank you guys for all of your support. Thank you so much to all of our Patreon patrons and to our channel members. As I always say, we appreciate you guys so much. Your support every month goes towards the monthly vet bill because aside from critical situations like this, I do take them on a fairly regular basis. Sybil goes more often than I wish she would, and thankfully right now she seems to be okay. So I'm not going to take her unless I think she needs it. But I pay my vet every other week. I have for years. So the money that you give helps to offset some of that. We appreciate you so much. I'm going to be doing probably another update. I'll decide that in the next couple of days. In the interim, as I always say, take care of yourselves, love one another, and we will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.